Welcome everyone to today's webinar, New York State Whistleblower Law Amendments, presented by Barclay Damon. Many thanks to our presenters, Michael Schiatti and Brianna Cristiano, for being with us today, and to all the participants who have joined in, and to our educational series sponsor, Chemung Canal Trust Company. Please note this webinar is being recorded to share what we learn with the business community. All attendees will receive the link to the recording. Michael and Brianna will share the presentation with you, then follow with time for questions and discussion. Please use the chat to submit any questions during the presentation. Just a reminder, when others are speaking, please keep your audio on mute to minimize background noise. With that said, I'll turn it over to Michael to start things off.
Thank you. Good morning, everyone, and welcome to today's webinar on the New York State Whistleblower Law Amendments. Brianna and myself will go through everything with you today. You know, it's going to be 40, 45 minutes or so, depending on questions. If you do have questions, please put them in the chat. We'll try to do them while we're going along. If we don't get to them, we'll do them at the very end in that regard. So with that, we'll get started. You know, some preliminary stuff here. Brianna's contact information and my contact information are both here. If you do think of a general question, you know, a few days from now, and all of a sudden you're like, God, I wish I asked it, you're free to email us. You know, as long as it's a general type question, we will answer and get back to you in that regard. So got something in the chat here. Okay, so in the chat right now, the materials went out, both the PowerPoint and the one attachment, which we will talk about. The other thing that I have here for you is I am on Twitter, I am on LinkedIn. I will let you, Twitter, you can just join. I'll let you in on LinkedIn. We post constantly labor and employment updates, in addition, regular updates about other legal issues in that regard. We also have a labor and employment podcast. It's very short, every single episode, but it's a good way to stay up to date on state and federal laws changing, policies and procedures. So I highly recommend that you take a look. If you did follow me on Twitter, you'll see every single episode there. We also have something else called CyberSip, which is, you know, basically what it implies. It's about your cyber, your computers, your network, and things you need to watch out for in that regard. So with that, let's talk a little bit about the New York State whistleblower law. Now, there are two. There's one for the general industry, which is section 740, which is what we're going to go over. And then there's section 741 for healthcare, which we're not going over in this presentation today. To be very frank with you, these cases were for employers to win. The law was clearly on our side prior to these amendments, and now it is clearly, in my opinion, did a 180, and it's going to be very difficult to get these cases thrown out and what's called a motion for summary judgment to avoid trial. So what we're dealing with here are a series of amendments that occurred to section 740 of the labor law, and that's what we're going to go through. There will be changes from prior law. We'll try to point out where the changes were, and then we're going to talk about prohibited retaliatory action, which is very broad in scope under the new amendments. We'll talk about some notification requirements. Brianna will pick it up here, and what it is like, you know, hypothetically, the employee is supposed to give notice to their employer before bringing a claim. I'll let Brianna go through that with you, but the question is vague. There's a series of exceptions. Do the exceptions eat up the rule? And I'll leave that for you to sort of make your own determination on. We'll go over the statute of limitations, that is the period of time within which a current or former employee can bring a claim, or now, as you're about to see, independent contractors can bring claims under this law. Brianna will also go over with you the damages that a plaintiff can obtain in this type of lawsuit now. And lastly, there is a posting requirement. We just sent that out in the chat as well. That must be posted with all your other employment posters in that regard. So first, let's talk about some general information. When did the amendments take effect? The rules went into effect, the amendments, back on January 26th of this year. And it's a very broad, very expansive, very pro-employee set of amendments in that regard you're about to see. So some changes to the prior law. So now one of the things that we have is there's a series of definitions in the law, and then some of them are big deals, the changes. And here's the first one. What is a employee? As all of you know, the first question on any labor and employment laws: who's a covered employer, who's a covered employee? Because if you don't get past those first two questions, the law probably doesn't apply to you in that regard. So basically, you know what an employee is: someone that's performing services under your direction and control for wages or other remuneration. The term now includes former employees or independent contractors. Now let that sink in. An independent contractor is not an employee. Well, what New York State has done is, in defining the term employee, they have incorporated independent contractors. This is something we're starting to see more and more here in New York. I think it's a trend, and I think it's a trend that's going to continue, that when the state of New York defines what an employee is, they are also going to start including now independent contractors. So we're seeing this more and more. The independent contractor has to be used to carry out the employer's business in that regard. So again, very broad definition. Big changes. It includes both current and former employees, and now includes independent contractors. So that's a big way the definition section has changed who potential plaintiffs are under this law. Now, an employer basically means any type of entity or an individual. If you have employees and you have one or more, you're covered in that regard. Doesn't matter to me if you're for-profit, a not-for-profit, a corporation, a sole proprietorship. None of that is going to make a difference. The law also defines what is a law, rule, or regulation. Now, the definition here is it's any federal, state, or local law, ordinance, or executive order. With COVID-19, we saw executive order after executive order, both at the federal, state, and local level in that regard, to the point where it's like, wow, I've never seen so many of these. Yeah, and no one had in that regard. And I think one of the reasons this law was passed was, prior to the change, if there was a violation of an executive order under the whistleblower law, you weren't able to do anything about it, but now you can in that regard. The second part of the definition is any rule or regulations regarding a statute, ordinance, or executive order, or any judicial or administrative decision, ruling, or order. Very broad in scope in that regard. So the big change here is the executive order in that regard, and any judicial or administrative decision, ruling, or order. So it's much broader than the prior existing law. The law also defines the term public body, and again, very broad in scope. It includes Congress, the state legislature, any elected local governmental body, or any member or employee thereof. That's pretty broad. So if I'm the staff person to the U.S. Congressperson, I'm potentially a public body because I'm an employee of a member of Congress. pretty broad in scope. It also includes any federal, state, or local court, or any member or employee thereof, or any grand or petite jury. Couple others, there's 4 more parts to it. It includes federal, state, or local regulatory agencies. It includes federal, state, or local enforcement agencies, prosecutors, and law enforcement. It includes any federal, state, or local department of an executive branch, or any division, board, bureau, office, committee, etc. of first 5 things. Basically, if it's the government, you're going to be covered. So they have made it so broad that whatever little tentacle it is of a federal government, the state government, or local government, it's pretty much now covered by the whistleblower of the law. The last thing I'm going to talk to you about before I turn it over to Brianna is retaliatory actions. What is a retaliatory action? It's any adverse action taken by an employer or their agent to discharge, termination, threaten, if you don't do this, I'm going to call ICE and have you deported in that regard. Let's say the person's here illegally. Penalize. I'm going to take away your salary. I'm going to change your hourly rate. I'm going to move your office from that nice corner office to a broom closet in the basement. I'm going to take away your company car. I'm going to take away, some other perk or privilege that you may have. And then there's the catch-all, or in any other manner discriminate against any employee or former employee for exercising their rights under this law. And as you're going to see when Brandon goes over a few of these things, it's very broad in that regard. It includes adverse employment actions or threats to take such or threats to take such action in terms and conditions of employment, including but not limited to our normal list of things: discharge, suspension, or demotion. That is typically what we think about as an adverse employment action. Actions or threats to take such actions that would adversely impact a former employee's current or future employment. Let's say it's a job reference that the current employee is asking for so they can get a new job, and they say, no, we're going to give you a nasty one because of X, and it's going to be a violation of the whistleblower statute. Or let's say the employee's moved on already. They have a new job, and they're suing their former employer for a whistleblower violation. And then the former employer calls them up and says, if you continue with this suit, I'm going to call your current employer and tell him you're a drug dealer in that regard. That would give way to another claim under the statute. Again, very broad what these claims now could encompass in that regard. And lastly, threatening to contact immigration authorities or otherwise reporting or threatening to report an employee's suspected citizenship or that of their family members or members of household. I'll be very frank. Gone are the days where an employer in New York could threaten to do so in that regard. So might mean employers did that. I'll tell you, yeah, they did, but not anymore, because you can't. And this is also a trend that we're seeing in New York law when they define retaliation, to protect individuals that are here illegally. They're adding this. So some changes to prior law. It now covers threats to take adverse action. It includes threats against former employees. So with that, Brianna, I'm going to turn it over to you at this point, or do you want me to do a few more slides? I forgot what you said.
You could stop right there. I think this is just outlining the things that you just discussed anyway. So we'll pick up at the next section.
Okay, so I'm going to mute myself and turn it right over to you.
Okay, so I'm going to pick up at the definition from supervisor under the amended provision. And under the amended provision, a supervisor is any individual within an employer's organization who has the authority to direct and control the work performance of the affected employee, or who has managerial authority to take corrective action regarding the violation of the law, rule, or regulation which the employee complains. Now, there's typically a lot of questions about who constitutes a supervisor and whether or not the action constitutes an action of a supervisor. So that this is the definition, but just to note that this is something that's subject to quite a bit of litigation typically. So under the amended provision, a prohibition is an employer shall not take any retaliatory action against an employee, whether or not within the scope of the employee's job duties, because such employee does any of the following: discloses or threatens to disclose to a supervisor or to a public body any activity, policy, practice of the employer that the employee reasonably believes is in violation of law, rule, or regulation, or that the employee reasonably believes poses a substantial and specific danger to the public health or safety. Now, there's an important difference here that we'll talk about in a moment, but this is how the law currently reads. So prohibition is also if an employee provides any information to or testifies before any public body conducting an investigation, hearing, or inquiry into any such activity, policy, or practice by the employer, or objects to or refuses to participate in any such activity, policy, or practice. So the important change from the prior law here is that you don't need proof of an actual violation of the employer of any law, rule, or regulation. Under the amendment, and I tried to kind of draw this out, but the employee only needs to prove that they reasonably believe that the employer's activity, policy, or practice is in violation of a law, rule, or regulation. So no longer does the employee need to prove that the employer was actually doing something wrong, just that the employee had a reasonable belief that that was going on. So that's a big difference to the employee's burden in these lawsuits. So the way the application is defined under the amended law is the protection against retaliatory action pertaining to disclosure to a public body, and then that shall not apply to any employee who makes such a disclosure to a public body unless the employee has made a good faith effort to notify his or her employer by bringing the activity, policy, or practice to the attention of either a supervisor or of the employer, and has afforded such employer a reasonable opportunity to correct the alleged violation. So there's a couple important changes in the way that that's defined now. Previously, an employee was required to bring the activity, policy, or practice to the attention of the supervisor and provide the employer with a reasonable opportunity to cure the improper activity, policy, or practice. Now, under the amendment, all that's required is that the employee has made a good faith effort to notify his or her employer of the violation. That's not defined. We don't know what a good faith effort entails. What will likely happen is that this will be litigated in the courts, and that's how we will get our definition of what constitutes a good faith effort under this provision. But that could potentially mean something like the employee writing a letter, or in other respects, a text message, an email, a report verbally to a supervisor. So all of those things could potentially constitute a good faith effort. Employer notification is not required where there is an imminent and serious danger to public health or safety. The employee reasonably believes that reporting to the supervisor would result in a destruction of evidence or other concealment of the activity, policy, or practice. That such activity, policy, or practice could be expected to lead to endangering the welfare of a minor. Or where reporting to the supervisor could result in physical harm to the employee or any other person. Or if the employee reasonably believes that the supervisor is already aware of the activity, policy, or practice and will not correct such activity, policy, or practice. So this is very broad. There's now, instead of the employee, by default being required to notify the employer that they feel that there's been some sort of violation. Now we have exceptions, which in essence swallow the rule. And so it's very likely that an employee can fit into one of these categories and absolve themselves of the requirement to notify the employer that they believe that there's some type of violation. I would say the most broad one is probably this category 5, where the employee, all that they have to show to absolve themselves of that requirement is that they reasonably believe that the employer would have already known that violation was going on. So if an employee pleads in a complaint, for example, I reasonably believe that because of X, Y, and Z, the employer would have been aware of that practice, then they're likely to be able to move forward on that claim. Okay, so the remedies for these violations. Employee who has been the subject of a retaliatory action may institute a civil action in a court of competent jurisdiction for relief within 2 years after the alleged retaliatory action was taken. Any action can be brought in the county where the retaliatory action occurred, where the complainant resides, or where the employer has its principal place of business. And notably, the parties now are entitled to a jury trial. It shall be a defense to any action that the retaliatory action was predicated upon grounds other than the employee's exercise of any rights protected by the law. So this is just a small defense that employers are able to raise in defense to one of these lawsuits. Okay, so a couple of changes to prior law. So first, and most importantly, an employee is now able to have a jury trial under these. So like Mike said earlier, while this used to be, very favorable to an employer in terms of the burden of proof that an employee was required to meet, now it's a little different. An employee could plead one of these claims, get a jury trial, and it kind of gets incorporated into a lot of the other discrimination and retaliatory action claims that we are more likely to see go forward. So that's definitely a change. And now we also have a 2-year statute of limitations. So potentially claims that had already been expired could now, see the light of day for a couple of months. And so a couple of big changes here in terms of remedies. Okay, so as far as relief, a court can order an injunction to restrain the employer from the continued violation, the reinstatement of an employee to the same position that they held prior to the retaliatory action. They could also be entitled to front pay if they're not reinstated, reinstatement of fringe benefits, seniority rights, compensation for lost wages, and any cost disbursements and attorney's fees paid by the employer to the employee for the cost of their litigation. A civil penalty could be assessed against the employer, and the employer may need to pay punitive damages if the violation was willful, malicious, or wanton. So a couple of changes to the prior law. Front pay in lieu of reinstatement is now able to be assessed against the employer if reinstatement isn't practicable or possible under the circumstances. We now have a civil penalty up to $10,000. And another important change is that punitive damages are available, which is obviously a danger to an employer because there's no, it's not where the civil penalty is capped at $10,000. There's more exposure under the punitive damages provision. So in addition to what we already talked about, a court can also order reasonable attorney's fees and court costs to an employer if the court determines that the action was brought with by the employee without any basis or law in fact. So that is an option that's available to the employer if this is just a lawsuit that's totally out of left field or has no basis or validity to it. Publication. So every employer has to inform employees of their protections, rights, and obligations under this section by posting a notice. Such notices will be posted conspicuously and easily accessible in well-lit places customarily frequented by employees. So again, this constitutes a change. A poster was not required before. So this is a new rule that employers need to be aware of. And in addition to the other postings in New York State and federal require, typically post your other posters that New York State requires in the break room, post it right next to them. It's not a different requirement, it's the same. We have a poster, so you don't have to come up with your own language. We would recommend just printing off the New York State poster, put it with your other ones, and that will cover your obligation under the provision. Okay, and so we talked a little bit, Mike mentioned earlier that there's a similar healthcare provision. And so, that is a different posting requirement, but this poster will cover the obligations under that as well. So, I'm going to turn it back over to Mike. He's going to go over some of the further handling requirements and any questions that may have come up. And thank you very much.
Thank you, Brianna. A couple things to keep in mind here. There is no employment handbook requirement. You don't have to add anything to your handbook, but it might be a good idea to add something like this. A section that allows an employee to complain about suspected violations of law. If an employee suspects that someone in the company is violating some federal, state, or local law, rule, or regulation, please file a complaint with so-and-so. We might be able to use that as a defense mechanism in one of these cases, remains to be seen, but I'd rather have you have it or not have it. Those of you that have employment practice liability insurance that protect against discrimination claims and whistleblower claims and retaliation claims. A couple things to keep in mind. The statute has punitive damages and fines associated with it. Punitive damages and fines are not covered by those policies. You cannot cover punitive damages and fines in New York State with insurance. That's on you. So I think one of the things you want to consider doing is some training for your supervisors, some training for your employees to educate them, believe it or not. Why? When you train, you mitigate or get rid of the punitive damage charge in that regard to the jury. So, it's good training, good policies, make sure the notice is up, and make sure, most importantly, you're complying with the law in that regard. And that's really all we wanted to tell you about this law today. It's much broader than it was. It is now pro-employee. We gave you some practical suggestions about 1, the notice, 2, what to put in the handbook, and 3, just beware, that we think you should train in that regard, because I think training is of paramount importance in trying to get rid of a punitive damage jury charge. Just tell the court jury charge on punitive damages is inappropriate. The reason is we do training on this. We have policy in place. The judge may find it to be a good reason to do so. So with that, I'm going to stop. But if you have questions, please put them in the chat now. I don't see any yet. If for some reason you think of a question in the next day or so, feel free to email us, and we'll be more than glad to respond. We are working with the chamber on a 2023 schedule. Preliminarily, we don't have topics lined up yet because it's early, but it looks like we're going to try to target maybe 6 presentations for the year. And, once we get some good topics on things that are new in the law, we'll probably go down that pathing and start getting some things scheduled for next year. But I see no questions. So with that, Beth, I'm going to turn it back over to you. And again, anyone that if you think of something, feel free to email Brianna and myself. All yours, Beth.
All right, great. Thank you. We will share the link to the recording with you later on, and you can visit chemungchamber.org to register for upcoming webinars or find recordings of previous webinars. Thank you to our presenters, Michael and Brianna, and to our educational series sponsor, Chemung Canal Trust Company. And thank you for everybody for joining us today. For anyone interested in chamber membership, please visit the Chemung Chamber at www.chemungchamber.org, or you can contact us at email info@chemungchamber.org or call 607-734-5137. Many thanks again and have a great day.
Take care, everyone.
Thank you.
Thanks, Bree.